part 3 of the computational law course at MIT.
Day one.
Day 1, that's right. Let's give a few minutes for people to log in here and start viewing. I might say a couple of things by way of housekeeping. One of those is that I'd sort of obliquely mentioned a little earlier that we're looking to do something kind of, well, a little bit edgy, a little bit innovative as part of capturing and collecting all the great presentations and ideas and new written works coming out of the course this year. And it's partly thanks to our teacher's assistant, Mila, who is a practicing attorney in Sao Paulo and chairs the Legal Hackers chapter there in Brazil, and is connected with Thomson Reuters Latin America, and kind of pass forward an idea that they might be interested in republishing some of the proceedings or some of things that happen and activities during the course to let people know more about computational law. So that was very interesting, and that kind of led to some more conversations, and that's where we kind of got this idea generally that maybe we ought to collect our materials and do a better job of it this year, and perhaps we can follow in the footsteps of our friends at Stanford Codex to some extent, who launched a blockchain the Stanford Journal of Blockchain Law and Policy. And that came out of basically the same broad community that we swim in, right?
CLB Fest.
Computational Law and Blockchain Festival, or Festivus to our friends. And so basically, we're going to try to connect. We're going to work on using PubPub, an open publishing platform, to start to collect some of the lectures and some of maybe the interesting outputs of student projects or small group discussions that are happening tomorrow and Thursday, and draft some blog posts, maybe some reviews, and some other, maybe some video or some other media types, right? And eventually maybe work on that through the CLB Fest 2019.
Massage it a little bit.
Iterate, and with the goal of launching some kind of periodical. Law review may be a little stodgy for our format taste, and MIT doesn't have a law school, and that's perfectly fine. But maybe something more like a fresh magazine, or some kind of new media publishing ground, right?
The sky's the limit.
The sky is the limit. It's the ether. So we're so the next presentation that we have is actually we kind of have two sessions for part 3 at the end of the day here, and they are computational contracts with Chris Behrendt, and basically information security, cryptography, and protocols. I would consider it, kind of a foundation setting course with Christian Smith. So the idea here is that we, again, really want to invite you to kind of go the extra mile this time in the pigeonholes for each of those sessions. First up being Chris Behrendt's Computational Contracts session page, so that we can be in more conversation with you. And what I'll do this time is I'm actually going to set the display parameters so that what we see is the most recent posted questions. So go ahead and upvote the ones that you find interesting, and we'll do that view from time to time. But we'd like to kind of up our level of game here and try to be more conversational, adaptive to the real-time stream of thoughts and questions and ideas coming from you. So what do people do one more time in order to do that?
You gotta go to the agenda page.
Okay. I'm going to do a little screen share. Boom. Okay. We're screen sharing, and so what do we first do? We somehow get to the class page. Here is the class page. We go to the agenda page.
Yep.
Boom. Click. Then we do what?
From there, scroll down to the session page. So that's going to be a little bit further down.
Okay, this is the sessions page, right?
Yep, and click Computational Contracts.
Right here. Chris Barrett, 215, our version of 215. Here is the, you can follow on the live stream right here on the same page, and you can, here we go. Oh, actually, it looks like we've got some meat in these bones already, which is great. And then you just add your questions and comments right here.
Yep.
Computational contracts, and here's Chris's overview from this year. Computational contracts are, I think, really essential to what we're going for in our take on computational law, at least the law.MIT.edu take. The law is a multifaceted thing. The law very much, some people when they say law, what they mean is what was the ruling that came from the Supreme Court or from another adjudicatory body.
Yeah.
Other people mean a statute. What did the legislature say? Other people think the law, especially these unitary executive people, think the law is whatever the president says, and the regulations and the policy set by executive branch agencies. We're getting a little bit of echo here.
I think Chris just joined.
Chris, are you with us?
I am.
Welcome. Okay, and I was just setting up the table for your talk, but a very important part of the law, and one that's especially well aligned to a global change in evolving law from a document kind of almost medieval paradigm to an information digital data-centered paradigm is contracts. Contracts are enforceable in law. They have rules. It's an important part of law, and it's the law that governs so much of our lives. Leases, licenses, and music are contracts. Commercial contracts. We already have good code for contracts, the Uniform Commercial Code and the Hague Convention on Contracts. It's legal, but it starts to structure some rules and create a nice taxonomy to start with. Yeah. And more to the point, perhaps, this is private law, not public law. So we don't have to go to the government and say, Mother, may I please have reform in law, and then see whether or when or what we get as a result of that. We can make our own darn contracts. Thank you very much. Freedom of contract is essential to this facet of the law. And not only can we make them, we can format them, we can structure them, we can express them largely however we want. And that means that we can find rapid adoption in interesting sectors of the economy and facets of society of people trying things new ways. And the law is very flexible when it comes to contracts, especially I mentioned the model, the United Nations Commission on International Trade Law model law on electronic commerce from the late 90s and other international legal conventions and implementations in different jurisdictions internationally are quite flexible with respect to different types of electronic contracts. And they're just looking to make sure that the key elements of offer and acceptance and adequate certainty and some other kind of procedural, almost like formats are there, but we can roll these things however we want. And Chris has been what I would consider another beacon, light of how high the ceiling for innovation is here from his work in the energy markets of structuring very complex multi-party contracts in ways where they are expressed digitally as network services that are data-driven and makes much more efficient business models and operations as a result. And so tickle pink, right, to have Chris. And you nailed it last year, Chris, by the way, which is why we invited you back this year. And so shall we get right into it?
I think that's a good call.
Okay, so hey, Chris, thank you for joining us. And you can come up. mute. I'll go on mute so we don't have feedback. And I want to welcome you. And if you could just say a few words to remind people who you are and just what your take on computational contracts is. You don't need to repeat your whole life, but maybe just back into the hot stream of computational contracts, and then we're going to start posing questions that are coming from our students from all around the world. We've got quite a backlog of people that want to talk to you.
That's great. Thanks, Daza. Can everyone hear me?
Yep.
Okay, great. My name is Chris Barrett. I am a transactional and regulatory attorney in the advanced energy space. I've been doing energy law in energy markets, environmental markets for quite some time. You know, I'm honored to be here with Daza and team, with all of you. When I think of computational contracts, I simply think of contracts that have automated properties that can do more than simply the letters on the page in terms of how they often implement. You know, at some point in the future, we might see contract formation and contract construction, you know, being handled more on a computational basis. But to date, and for the most part, when I think about computational contracts, I think of agreements that, regardless of how they're expressed, are able to implement and execute in a manner that automates certain functions, usually a processes. So that's kind of how I think of computational contracts. But you know, the field that encompasses that term is certainly expanding.
Oops. One.
I can see the beard. I can't hear your voice.
Okay. How about now?
Yeah, now I can see you behind Brian, and I can hear you.
Okay. Perfect. So here we go.
There you go.
Boom. There's Brian, and here I am. Okay. So let's get right into some of these interesting questions. So the highest rated, the crowd favorite is for it comes from Jose Rodriguez. For more traditional legal ecosystems, what would you say are the first steps to implementing computational contracts or document automation? Is there a right critical path? Do you kind of get what Jose is asking?
Is there an area of the law that seems to be adopting it quicker than others?
Well, I think he's saying there's a scope which is for more traditional legal ecosystems, and I'm not exactly sure what he means by that. But if we can, I'm thinking big law firm. I'm thinking maybe regulatory agencies, or regulatory, heavily regulated environments like energy and I don't know, transportation, perhaps in some ways. What would be the way to begin to expressing these contracts as computational systems?
It's an interesting question, and we're seeing, you know, the legal community is very slow to come around to using new tools and new systems and so on. I like to joke, it's often lawyers' clients who are utilizing more advanced tools and techniques who sometimes drag their lawyers kicking and screaming into the future. I think from a very, very basic ecosystem level, at the highest level, where you're talking about like a civil law versus common law jurisdiction, there's a lot of dynamics of a civil law jurisdiction that lend themselves to computational processes. You know, you tend to have in civil law jurisdictions kind of less of a bandwidth on where interpretation can come out and so on than common law jurisdictions. You know, from a legal ecosystem standpoint, who's using computational contracts and so on, the leaders in automation tend to be folks who are using master agreements for trading different types of commodities, securities, and so on. You know, the whole world of the over-the-counter markets, exchange-traded markets, and so on, has taken, I would say, initial advantage, kind of first-generation advantage when it comes to what can get automated from a computational perspective. There's still a lot that human beings are doing at trading desks to help effectuate it. And so from the legal perspective, the agreements that are used like that have an opportunity to take on more express computational dynamics, more of an opportunity to kind of reference and plug into automated processes, systems, and so on. And sometimes you certainly do see that at the confirmation level of deals. But there's unfortunately not a lot of kind of computational dynamics, automated dynamics that I'm seeing going into, you know, contractual frameworks, beyond some of the, you know, kind of cutting edge stuff that's happening in the energy space, the manufacturing space, and things like that. I think the litigators haven't really, you know, other than looking at big data analytics and so on for e-discovery and things like that, there's not been that much activity on litigators using automated computational dynamics other than what might exist in, you know, programs that they use for risk analytics around, you know, jury selections, verdicts, things like that. So from a legal ecosystem standpoint, I think drafting contracts that have automated functions is happening, but it's still, you know, in the evolutionary stages. And a lot of law firms in particular, in-house counsel, you know, lawyers in general are still getting used to how those dynamics play out. I mean, to be perfectly frank, as an attorney, you try to draft agreements whose outcomes are fairly certain and static, where you know if this is elected, if this happens or so on, this is what the outcome is going to be. You know, so-and-so is going to sell this to somebody for this price, or so-and-so is going to be responsible to undertake this service and such. And, you know, automation is a little scary in the legal field because it represents, you know, less of a kind of, you know, single track stovepipe static outcome and more of the opportunity for, you know, a whole range of various outcomes and so on. And so I do think a lot of people, where they're used to drafting, you know, agreements so that that variation can take place in how, you know, the weekly, you know, confirmation or delivery tracking sheet or order sheet gets filled out between the parties, seeing that kind of automation up at the actual agreement level, in how that agreement, might select overall service provision, overall product provision, and so on, is still in the early stages. The automated contract systems I talked about in my last talk, and that I've talked about with Daz and others, are, whether they're regardless of how they're expressed, and on what kind of, server or system or whatnot, they're functionally master agreements that allow for a lot of variation and triggering of different deals and confirmations. And the agreement itself still has a long way to go before its construction, expression, interpretation takes on automated computational dynamics. Right now, I still see it as an implementation execution game with computational dynamics.
Here. So that's a perfect segue into the most recent question that came out. We started with the highest voted. And do you mind posing the question? And then I want to maybe frame it a little bit for Chris.
Yeah. So Brendan wonders, could you talk a little bit about how you see master contract, like kind of like the configuration of master contracts and subcontracts evolving?
Yeah. And if I could frame that just a little bit, could you first of all explain, so everybody knows, in larger contract systems, more complex contract systems, there's layers, and if you, or maybe master contract speaks to this umbrella. So when I mentioned EDI earlier, electronic data interchange for procurement systems, we would have a partner agreement that indicated, some of the high-level rules and scope and purposes, governance of the trading system. And then we have specific participation agreements. So, I'm Office Depot, I'm Staples, Office Max, I'm this state government corporation, and this big now we're going to use these kinds of, I agree to certain rights and obligations. And then at the general level, you may have transactions, request to quote, send a purchase, send an acknowledgement that the goods were received, send an invoice, an acknowledgement payment occurred, and lots of variations in there. So you've got this transactional system, you've got this basic opt-in contract, in which the parties agree to be bound by the rules and procedures of the overall system, and agree to pay when an invoice is sent after these types of messages occurred. And then you've got the overarching master agreement, which among other things, at least in this technology-infused purchasing kind of context, would say, here's the types of parties that can be buyers, here's the types of parties that can be sellers. We're going to use this standard or this dialect of XML. We're going to have these service interfaces. You'll onboard your systems in the following way. We need listing of the points of contact for these things. We will accept these types of payment things, et cetera, et cetera, et cetera. So could you extrapolate a little bit on Brandon's question of how do you see the use and evolution of master contracts and subcontracts as how we can structure these new types of trading systems and ecologies of transactions going forward?
Sure. Where to start here? So, I mean, Daza, you characterized it well. A master agreement is essentially an agreement that two parties put in place saying, in the future at certain times, we will undertake certain transactions in accordance with this agreement. And a master agreement tends to have all of the terms in it that would apply to any transaction between the parties. It's very common that you put in place a master agreement, and in that master agreement, in the back, in the exhibits, is what's called a form of confirmation, which essentially says, hey, when we transact, this is the form where I'm going to say, I'm requesting this many widgets from you, or you're saying I'm going to sell you this many, widgets, or I'm going to provide this much of this type of service, or you're going to provide this type of this much service. So a master agreement usually has, the basic scope of what the parties plan to do between them, payment terms, credit terms, liability terms, dispute resolution, stuff that kind of would apply specifically to each transaction regardless. Confirmation is where you often have the details on the numbers of how much, when, how much of something, how much am I going to pay you for it, and when am I going to get it and where. To date, many parties have set up many types of master agreements. And I'll note that sometimes a master agreement will be what is also called a standard or model agreement. Those agreements sometimes are developed by specific entities. So if you have an entity that's a big player in its industry, in its sector, I've worked with folks like that to develop their standard agreement, where we basically then tell all of their suppliers and vendors, guess what, guys, you're using this. And if you want to work with us, this is what you're using. Sectors, industries will also get together and create what are called model agreements, where you'll have a drafting committee of representatives from a bunch of different companies and law firms and stuff, and everyone will get together and they'll draft up an agreement kind of deemed a model agreement that is meant to be a common master that everybody in that sector can use to standardize as much as they can the terms that people are transacting under. And so, you could have a master agreement that's just a bespoke one that's whipped up between two parties to handle a very customized situation. You could have someone develop a master agreement that's kind of their standard agreement where they say, if you want to do business with me, this is the paper we're using. And you can have whole sectors that develop model agreements where everyone tends to use that same model agreement plus, and deals are effectively customized by having an amendment to the model agreement that you negotiate that says this is added to this provision, this is taken from this provision, and we're electing, blank, blank, and blank on these schedules. So there's different versions of it. To date, most of those agreements get put in place by the legal teams working with the business teams. They get done on paper. We share electronic copies. It gets put into file, and then it really only gets pulled out if there's an issue. And most of the activity is taken over at the business level by the exchange of confirmations. The automation that's really emerged to date has been in when I have a master agreement with multiple different parties. And it's normal for you to set up a stack of master agreements with a lot of different suppliers, vendors, and customers. And that stack of agreements can, at any given time, have like a specific set of agreements within that stack be exercised to a certain level and in a certain way. So I might decide to buy some stuff from some vendors, sell some stuff to some customers, line up this supplier to do this next month. And that whole constellation of how those agreements are being positioned through daily confirmations coming out, with it from the masters that are in place, that can happen, in any number of different ways. And so most of the automation I see in computational contracts to date has been automation that reflects how do we take a group of assets, whether it be an industrial park, a manufacturer plus a power plant, whether it be a whole portfolio of assets, how can we position those based on market values and values that we've established under agreements with counterparties? How can we take that kind of constellations of different asset positioning and pick the one that is worth the most money, that optimizes the best? And so to date, most of the automation we see in computational contracts have been focused on providing an automated process of selecting which confirms get sent to which counterparties and what the numbers go into each of those confirms. And then in a lot of instances, we set it up so the confirm itself exchanges electronically, or you automate the exercise of the confirm and the transaction between the parties. And it just happens on its own unless someone raises their hand and says stop. So it's kind of, again, at that implementation level, but the future is going to hold some interesting things for how contracts get constructed and expressed from a computational, kind of basis. But for now, that's where we see kind of most of it. And quite frankly, if you look at like the smart contract, the contract account on Ethereum and so on, most of quote unquote smart contracts, computational contracts that you see out there, are basic, agreements just expressed electronically that say when this thing happens, when the status of whatever it might be changes from X to Y, this action happens, and maybe that's so-and-so gets this many tokens at this rate, so-and-so gets sold this much at this whatever, or so on. But it's, for the most part, it's fairly simple mechanisms that we're seeing, in place right now. And, it's going to be interesting in the future to see how far up the contractual development chain automation and computational dynamics can reach.
Can I say one thing?
Yeah.
So we have a couple of comments on that. One thing I just want to highlight is I'd like people to take away from this, and maybe our erstwhile scribes could include as future work for us to fill out in the notes. There's a basic architecture when you're structuring these contracts for electronic transactional systems or other types of systems. That works pretty well. It's an engineered architecture that includes a high-level contract that sort of sets things that apply to the whole community, and has some things like, who's in and who's out. What is the scope of kind of interactions we'll have here, or assets, or in transactions? How do you get kicked out? Maybe. Yeah. Who decides when there's disputes? It would be another thing at a high level. So you could actually have a kind of a internal dispute resolution is not so unusual, so that you can start to look at ways to de-link to express this largely as a private international law system that's time honored in terms of its enforceability and allowing you to have predictable legal outcomes. And so the architecture I want you to think of is, imagine designing an electronic contract, or even how you could have smart contracts fit into. What if you had a paper master agreement that indicated here's our system for whether it's a DAO or otherwise, or just more mundane transactions. And if you want to be in on it, we're conducting this swath of interactions through blockchains. Kind of the way that you do it is ABC, and we're going to gap fill all of the like maybe indemnification and liability, and when the risk of loss changes, how we're going to evolve and update the technical standards. Look to the master contract for that stuff, and then look to these smart contracts for more transactional kinds of things. This would be like a first grade level, in a sense, way to apply how to use master contracts, this system. A lot of people that are doing this stuff may not be that sophisticated, and they maybe haven't suffered for decades with master contracts, as some of us have. But I want to encourage you to just think about just delinking a master contract from maybe participation agreements, where you agree to be bound by the master contract, and then transactional messages for like buy, sell, trade, license, whatever. This is really important, and so thank you, Brandon, for bringing that up. So now this also kind of gives us some thoughts in the insurance industry and some other sectors. Although Vicky raised her hand, should we defer?
Yeah, I just wanted to make a comment that is precisely the way I think you should think about with music, is because music.
Could I ask you to come here? Not only because it makes better video, but also we want to hear you. Thanks, Vicky.
Yeah, so my comment was that is precisely the way to think about it with music, because almost any licensor agreement has, really broad reaching indemnifications, usages, approved uses, all sorts of different things that couldn't possibly be incorporated into a small transaction. But then the deal points and the things that I put at the end of my deck, there's really just a short list of deal points in any kind of music contract. And these can be supported by business rules in a platform. They could be supported by smart contracts, and they're things like the territory, the rights calculation, the functionality, the way something is going to be reported and logged and tracked according to metadata. It's really a very short list of things that are critical for that on a transactional level.
Here. And there's so much, Brian gave me one note, which I want to put ahead of what you're going to say, on BLT, not just a delicious sandwich, but it's also a approach to incorporating business, legal, and technical dimensions of in this case, a trading system, say, for example. Right. And so it's quintessential, and I would say, fundamental things that you would want to have said once in a master contract, and you don't want to renegotiate or repeat every time, or worse yet, repeat a little differently every time in transactional agreements. Like, when do you decide when we're going from this version of the core system to version 1.1, or how do you get it? What registries are authoritative for certain kinds of things? What is the current version of API with the minimum metadata for this type of oracle? Because it's basic stuff. but we cannot have it always be subject to my interpretation of a string of issues in several repos in GitHub. Like that is not and legal, predictable legal outcomes. For some types of things, it may be desirable to spell out what we all agree, and if we do agree, then we can spell them out at a master level, and then we can have like speed of thought transactions at the lower level, and we can also, as part of my career used to be helping, sometimes many party organizations craft the change management of the master contract, because you might want to change how those decisions are made or who's in and who's out. And it's good if there's some process where people can propose change, it can be considered, it can be agreed somehow, and then it can be staged and phased. So like, we're going to change the master agreement in like 14 months. Okay, in 12 months, in 8 months. You can get out without owing anything in 6 months. So decide if you like this or not.
Exactly.
You know?
Exactly. Or differences in, like in music world, differences in royalty calculations might change once you reach a threshold.
Yes.
And then there's a different range. And then you'd have, of course, in a decentralized environment, you'd actually be able to trace that back and see there's a point at which the calculation changed. Everything before that is reflected, everything after it is something different.
Now we're getting into adaptive systems and truly computational, not just contracts, but also the governance layer. And when we get good at this, the way Chris is quite good in the energy sector, some of these calculations can be based on algorithms and merit order. So it's not like in the 90s, it literally was months of time and meetings and back and forth to do these things. This could be reduced to weeks and days and hours.
Minutes, even if you do it. I love the examples from music because I think they're quite apt, and we've experienced. I mean, to a certain degree, if you're whether it's intellectual property and instruments that reflect it, commodities, services, there's a lot of similar dynamics. I think the first generation of computational dynamics that that the attorneys put in place was to not get yelled at by the business folks that we were slowing transactions down because they wanted to get a deal done, get it done quick, take advantage of the market environment, as it were, whatever deal was. And so I think the first generation of computational dynamics and automation in contracting, felt like it was there for the lawyers to catch up to speed with what the business folks wanted. And it was really kind of more of a, the phone rings and then, we try to make the outbound, executory computational dynamics as close as possible on the agreement. I think what we're going to be seeing in the future is a lot of inbound dynamics as well, where to use a royalty example, maybe you have an agreement where the nature of the royalty is being formed by a whole bunch of market data, wherein if this number is here and this number is there, the royalties at this level versus that level. And I think what I'm seeing in terms of automated contract systems and much of the future of this is the process of pulling market data into the consideration for how transactions are going to handle is less and less happening, kind of just with a human pulling market data, at their desk on a daily basis, but is more happening on an automated basis, showing what different profiles for, market conditions look like. And that inbound data is coming in more and more complex data sets. There's richer and richer data available to folks who are doing trading, to the business folks. And what I'm hearing from those business folks is we want to not only be able to do automation on the back end for how we choose what confirms we're going to execute at any given moment, but and to be able to do transactions quickly, but we also want to have a certain level of automation on the inbound data so that for a lot of traders and for a lot of people doing deals, the future is going to be less kind of, I'm looking at this and then I'm making these orders and I'm kind of going from one spreadsheet to another manually. And it's going to be more and more watching a flow of inbound data, profiling market conditions that then trigger certain sequences, automated sequences of confirmation sets at different time periods and so on going forth. And so we're going to see more kind of inbound automation and forming of data sets into systems that can accept that, as well as more stuff coming on the back end. And the challenge is for lawyers is how do we create something that is open to be able to flow that inbound data and that outbound data, and do it in a way that there's really appropriate breakers in the system. So just as the business folks are going to looking at more of kind of flows of data to transactions, as opposed to kind of manually processing market data and then choosing transactions, as they're looking at more of kind of a flow of automation, the lawyers have to do the same thing. And we got to work with the business folks to say, what are the breakers, the circuit breakers we got to put in here? Under what conditions should this flow stop? If the market, if any market number, exceeds this bandwidth, positive or negative percentage-wise, should that stop the system and open up, a dynamic and so on? In the past, a lot of that hasn't been automated and those questions haven't come up, and the system tends to be stopped manually by the trader. But in the future, we're going to have to look from a legal perspective, what are their systems that would, stop the overall flow of services? And, quite frankly, are there things that would substantially change, even the liability terms and other dynamics? There's a lot of different levers that can be moved under a master contract between the parties. And the question is how can you kind of get to that? So, the future is lawyers going to have to figure out how to watch those data flows. And it's going to be less of just how can we make the transaction paper and execute and automate enough so that the business folks aren't angry at us that we're slowing down business, the flow of business process and stuff like that. But also how can we work with those business folks to look at how that stream of data to transactions, can get optimized, and again, importantly, what breakers go into that system when we have to, basically take it out of an automated ecosystem, stop the flows, and begin some level of manual review.
Hear, hear. And so, Chris, we just want to say we love you. Come back sometime soon in person and hack with us. Yeah. And let's get you back on the whiteboard. But you're speaking the gospel of law.MIT.edu, and it's it doesn't go without saying. So thank you for sharing from your legal practice experience. A quick note on time. We're tracking a little behind. We planned for this, and so what we're going to do is have the session go another 5-ish minutes, and then we're going to reduce the wrap up at the end of. Is it okay if we extend the time a little bit, Christian? Okay, well then so we were going to close this the next session. It was going to go from 3 o'clock to 3:30, and so we'll go from 3:15 to 3:45. So we'll move it forward about 15 minutes, and then we'll reduce the time for wrap up at the end of the day to about 15 minutes, and perhaps we may extend a little beyond 4 p.m. I'm just saying, Eastern. So with that, there's and that's at no additional charge, by the way. And so, Brian, you have been busting at the seams with some reflections on this in the insurance context.
So it's not necessarily computational right now. A lot of the especially the commercial insurance carriers and brokers, many of them have only recently gone digital. Within the last 10 or 15 years. But the way that insurance policies have been structured for a very long time is very much in line with kind of this object model sort of approach of creating something that can be used in a bunch of different contexts. And what I mean by that is with an insurance policy, your basic insurance policy object model is you're going to have a set of declarations where you kind of declare what have a broad coverage form, and then in addition to that coverage form, you will have a series of endorsements which modify the policy in a certain specific way that is tailored to your specific kind of like use case or example. And while it's not yet at a point where it can be computed, that has gone on for a long period of time, and that many people, especially in the insurance industry, like. But I think that there could be some lessons to be learned there as far as, if we started doing this with, I'm selling a widget from my factory, and I've got my general master services agreement, but I've also got, a special deal for corporations and individuals who align with my interests, and a different deal for those that don't. You can kind of start playing around with how you want your contracts to be set up.
Here. And in the kind of commercial contracting space, as opposed to in the way that insurance policies are structured, which is pretty specific. The term schedules is very common. So you could have like a schedule under a master contract, or that sets even like lower price terms, or slightly more or less, or different sets of offerings and products, different delivery terms or whatever. Right? Am I speaking the truth, Chris?
Yeah. No. I mean, you can have any number of exhibit schedules that lay out sometimes a complex dynamic on how someone's getting charged, when it can get service or product can get, exchanged between the parties and so on. So yeah, it's there's certainly a lot of different ways that can get set forth.
Layer of master contract, kind of opt-in agreement and transactions, but there's other types of creatures, like a schedule is almost its own creature. The idea of having almost like objects that can be reused at different points in transactions or across different schedules.
A constellation of objects.
Objects is another very fruitful way to think about how to encapsulate legal terms such that they can be addressed computationally. Yep. So we can begin to engineer the law the MIT way. And just the way of science and engineering in general.
And which of those objects govern? I mean, that's often, does the confirm govern? Does the payment and, the schedule of payment and terms govern? Does the master agreement govern? And then you have different circumstances where which agreement in a document suite where governance might change between agreements. And so, yeah, there's a lot of interesting stuff on that front.
Here.
Yeah.
So I wish we had a lot more time. You want to say
I was just gonna say, if it I think with tags and like getting into tagging those objects with specific pieces of information, that opens up a lot of cool possibilities there.
Here.
Oh, yeah.
Labels. I'm sorry, Chris. Mr. Barrett?
No, I was just agreeing with Brian.
Okay. Yep. Here. Okay. So Chris, we've got a lot of people with a lot more questions than we have time to address right now. So I think one thing we can observe, by the way, is this flipped classroom thing is definitely the way to go. So you can become familiar with the idea, and then we can get right to the juice of questions. We can get better at lining the questions up so we can hit more of them, and maybe perhaps we can even become more asynchronous with how we do your questions. It doesn't have to be one day at one moment in time sequentially. Maybe we can find more ways to do that. In that spirit, and also trying to wheedle a little bit more of your time, Chris, well, if we were to take some of the best of questions we didn't get to and share them with you, by email later, could we maybe get a little bit more of your thoughts and share it back with the group?
Sure. Yeah, we can set up something like that where we can record some responses. I'm happy to take a few more questions.
That would be great. And don't worry, there's not a tight timeline on that. Something I mentioned earlier is we're going to be rolling up from this class through the next Computational Law and Blockchain Festival, a global distributed event in March. So we'll have time as we work together on other projects, Chris, to where I can find a gentle way to get some of your feedback and make sure we get it back to the audience, so to the student. Thank you so much, Chris, for your time. We're really, really grateful for you setting these foundation stones of computational law in the contracts context. You're welcome to stay with us. I'm going to ask Christian Smith if he'd join us now so we can get into some more foundation stones in cryptography, information security, and protocols. But Chris, just bless you and thank you for your time and sharing your wisdom.
Well, thanks, Daza. You're too kind, and I'm looking forward to answering the follow-up questions. And I will hang out and listen to Chris as much as I can. I'm always interested to hear what's coming out of Stranger Labs and the like. So it's always good stuff. So I'll catch you guys later. Take care.
Thanks, Chris. Bye now. And the plug for this plug and play guest, it was Stranger Labs, and Christian Smith and I met. Oh, so we're going now to the next session, which is the cryptography, information security, cryptography, and protocols. So please join us on that page to continue posing your questions and ideas and other comments, and we'll keep that flow going. Could I ask you to help with that?
Yeah.
Okay. And so I want to just introduce and thank Christian Smith for coming and sharing this core aspect of computation itself, which is security. And that's how we get to some of these primitives. We're using words like primitives in law, but they really do source from this field. And we first met when actually first knew about you when you were working on Anvil, which is a really great open source project implementing the OpenID Connect protocol for token-based kind of multi-environment access authorization tokens, and it's an interesting identity-related protocol. And then you came to MIT and did some, I think, really great work and formed some great relationships. Now you've graduated to a startup, Stranger Labs, where you're taking some of the best of your previous work and thought leadership and making it available, to the bigger, wider world. And so I'm glad that you were able to come back and spend some time with us during a work day. What's going on? Oh, is that just too trippy? Oh, okay. Great. And to have given a bit of a lecture already, laying out some of the foundations and to talk to us about it. So I was wondering if you could just, first of all, just by way of introduction, say just a few more words about your world and like, what are you doing at Stranger Labs, and what is your angle in this whole big world of security?
So I kind of got into this space to begin with because I was working on a bunch of different startup ideas with different people and different projects, and we found that we didn't have the kind of infrastructure that we needed to execute some of the ideas that we had. And as a result of that, I ended up finding all these open standards, and at the time, efforts to create standards that were really interesting. And we wanted to use that stuff. We wanted to have the same kind of capabilities as the Googles of the world, but at this early stage level, which is a little bit crazy. The business guys will tell you don't do that. But for us, for the ideas we were working on, that was really, really necessary to have that capability. And since this stuff didn't exist in a way that was accessible to us, we just started reading RFCs and writing code. And that's
an RFC is a way to express a standard, or like a protocol.
Yeah, it's a specification. It's the Internet Engineering Task Force is one of the big standards bodies, and they don't actually believe in standards per se.
Right.
You never quite get to the level of a standard. There initially it's kind of a weird, cultish set of ideas about these things. You hear a lot of people talking about standards today, and they have a really different take, IETF does, than some of the other groups like W3C, which is an interesting subject that we could pursue at length. But to finish the background, I got into cryptography by implementing these specs, and it's kind of a paint by numbers thing that's very elaborate and requires very precise programming and real attention to detail. And then when you put it out in the wild and you want these things to interoperate with other products that are speaking the same language or using the same protocols, those little tiny details, just from the hell and pain of writing the code to implement these protocols, and at every step of the way trying to understand it, that's how I got into the space and started to learn about this.
And so what I guess, just in a nutshell, like what do you do? Like what is your job, and what is Stranger Labs, and what does it even mean to have a work that involves in cryptography? Like, you sit around encrypting things, or you sell something, or like, what are you even talking about?
So we're a sort of positioned in the gray area between research and commercialization right now. We're working on some ideas that are a little too broad and require a little too much implementation to fit well in an academic research environment. Yeah. But they're not quite ready for VC-backed commercialization. And the area that we're working on is privacy and data protection stuff. Yes. We have some new ideas about how to approach privacy and data protection, and the kind of computing architecture and network architectures that can make that possible. And what we've been exploring is some of the fundamental limitations in the way the web works and the way traditional databases work, and in some of the newer ideas that people are exploring, blockchain and IPFS and different things like this. They're using cryptographic protocols, but they're using them for and primitives, but they're using them for very specific purposes, and sometimes not always hitting the right buttons when it comes to privacy and data protection.
Here. Great. So I want to just kind of launch us off by asking a couple questions myself. I'm wondering, what could the law learn, or what could people trying to do innovation in law learn from best practices and I guess solved problems in the crypto and security space?
So one thing would be, the first thing would be the right attitude coming into it. This is surprisingly, it's a non-technical thing, but attitude is really important. It's good to have a scientific attitude and have the curiosity and excitement that really helps to drive science forward. Those are acceptable emotions in science, where, let's say, rage or something like that, it's not a useful emotion. So that's good. But there's another kind of emotion that's kind of counterproductive, which is, you've seen a lot of this in the blockchain space in the past couple of years, where people want to create one ring to rule them all,
right?
And they get really caught up in egos around what we're doing. You can usually tell this when somebody's speaking in hushed tones, and I'm going to tell you what I'm working on, and it's a secret. Don't go tell everybody, but don't tell everybody.
To change everything.
And I think did you guys ever read the Kruger-Dunning paper? It's a psych paper. It's pretty good, and it talks about this is, I will bring this around so that it's relevant. It talks about being unskilled and unaware that you're unskilled, right? And there's a kind of bold arrogance that goes along with that, and when you combine that with maybe some dangerous or difficult subject matter, the results aren't always good, right?
Yeah.
So I think cryptography is just so damn hard.
So in that paper, there's like, you're skilled and you know it, you're unskilled and you know it, you're unskilled and you don't know it.
Right. So, which is the worst one. They're also making the case that by being unskilled, you're not aware that you're unskilled. So those things play off of each other. You're not able to make those next steps. And cryptography is this really, really humbling subject. It's so hard that even professional cryptographers, when they get it wrong, it's not that embarrassing. You kind of expect that whatever you do is going to break, and you put it out there and want to have some real scrutiny, and know that this thing that I make, I can't break it. Someone else can break it, but I can't, because of the assumptions that I have built into my head and the thought process that went into making it. It's someone else that's going to find flaws and break this. And there's a kind of a timeline that's lost on a lot of folks of what it takes for cryptography to become acceptable, for a new protocol to become acceptable, or a new technique or a new primitive. There's a timeline where a lot of people are critically evaluating these things and tearing them apart. The more, the better. And then there's a half-life once they're created, because the context changes, and something that was valid today might not be that great 5 years from now, right?
So a question that that comes to my mind, and then I'm gonna turn to Brian to ask what we have so far from the audience, and also just I want to pump you up a little bit here, please. I know you're listening, and some of this is new to some of you, but if you have questions, ideas, comments, including just what does an acronym mean or anything, bring it, and we're monitoring that. But a question comes to my mind in terms of attitude, which is such a great. I wasn't sure what you were going to say when I asked the question on attitude and practices and culture. In science, and certainly in cryptography, we have the scientific method, which is based upon very almost like harsh in a merit-based sense, peer review, and in order to test the assumptions and test the implementation, and then we at some point think it's good enough. But more to the point, we put it out there in some way that people can see it and can try to break it by invitation.
Yeah. Right.
And then in that way, and so this is a completely different mindset from the mindset of the ring to rule them all. And there's a successful design pattern out there, which is we're going to invest in something, we're going to build it the best we can, we're going to try to just assert it / force it a little bit into existence. That if we were familiar with that, but now I want to explore this other interesting way, which is certainly not familiar in the field of law, where we prize secrecy and we don't always want people to review, frequently don't want people to review our work. There's some client confidentiality caught up in that confidentiality, but it's more of an adversarial. You mentioned emotions like rage and other sensitivity are not unknown. What if we had a standard agreement before it went live that had an open publish comment period and a bounty? What if we said, okay, show us like the most common scenarios that you can say are statistically not unlikely, then that would cause litigation or liability or harm exceeding $50,000 within the first 2 months.
Yeah.
And then if you can prove those, you get a little reward. And guess what? We amend it and we amend it until we feel like our work in the law is good enough. That would that be an example of this other culture?
I think so. I think so.
Like pen test my smart contract on GitHub.
Yes.
There's another example that law could borrow would be the idea of a blue team, red team.
Okay.
Right. So where you have one team that's tasked with protection and the other team that's tasked with how do I break this? How do I break the security, capture the flag?
Here. Yeah. Blue team, red team.
Yeah.
So almost like adversarial network kind of a way to battle test and then to evaluate and assess with some rational evidence.
Our friend Bob Craig.
Oh yeah.
Actually, Bob and I have had some really good conversations, and one he talks about how
CIO of Baker Hostetler, big law firm.
He talks about how law is really kind of wait and see. It's really reactive, right? And one of the things that's interesting about some of the recent legislation, like GDPR, is that it's a little more proactive, kind of getting out there and reasoning and building up from principles. And put forward this, this law and leave it kind of ambiguous and then sort out some of the, ambiguities in court. But can you try to, can you try to even formally or by some method of generating, cases that cover some of those dark corners? Can you do simulations? Can you talk about this stuff?
Amen.
Can you, we do attack simulations. Sinjin over there does some penetration testing stuff, and just in the law on purpose and see what happens and see what kind of cases you might come up with.
Here, and that very much gets us back to this idea, which is almost an axiomatic at law.MIT.edu of can we engineer things so we have predictable legal outcomes? And simulation is a time-honored way to do that. So, okay, what do we need to have a simulation do? What must it simulate? And when do we have the right data? And when do we have the right kind of rules? And what is the right statistical model and other algorithms so that we're adequately simulating the relevant factors so that we can establish a rational basis for predicting the legal outcomes in a certain matter. I like where you're heading with all this. Let me ask a question now. What do we have from our students?
Yeah, so most recent question kind of wonders about how we could combine, law to some of these information security principles in order to set up computational legal frameworks that are kind of more in line with what we're seeing in like the information security community.
Well, I think the first step to this is actually literacy. There's a fundamental literacy problem because this is multidisciplinary, right? And I think people working in security aren't always super literate in the legal matters, and people on the legal side of things aren't super literate or aware, and oftentimes very badly misinformed about the technological and cryptographic aspects of things. So the first step there is probably to fix that literacy issue, address that by having some cross-pollination and having both communities start to proactively try to understand each other and develop some common language would be a good way to do that.
Do you remember that first good conversation we had when we met out at Central Square? And we ended up, you walked me all the way back to my storage container. What was going to be like a 30-second, hey, don't you work at MIT? And then it was very involved, where we got deep into Alice and Bob and non-repudiation. I was playing through all these different permutations of legal scenarios when people could repudiate something, and we went pretty deep. And I'd say that was, in my book, that would be a good example of cross-pollination, and beginning to understand some of the vantage point and even vocabulary. Sometimes we're saying the same things with different words. Sometimes we're saying different things with the same words. And sometimes we're saying we have different words and we're saying different things. Being able to be literate enough to be conversant in these things would go such a long way.
You have to be able to map the concepts back and forth before you can start saying which principles apply and how can we build on this. And that's a conversation that needs to get started. I don't think there's a quick and easy path to going back to the question. I think, did we cover it?
Yeah. And now we just had a nice burst of questions. Anything else catch your eye, Brian? Your camera.
Anne's got a good question that I think would be interesting. It could be interesting in terms of like actually seeing something like this at maybe like a B-sides or something, but are there databases out there that could be used to do some of these simulations where maybe you're trying to do a red team, blue team sort of thing, or capture the flag with something that's in a database, but that you can play with and break down and,
I don't know anything like that.
Okay.
Yeah, I'm not sure what the question means. Something that's in a database?
Yeah, well, so databases of like, I would imagine like fake legal data that you could use to kind of see where vulnerabilities might exist, or maybe something like the Enron.
Yep. Yeah, exactly where I was going.
Yeah.
So can I try to reframe the question a little, just based on the way Brian said it? We used to have some legal hackathons where we would take data sets that could exist in a database, like we usually got a big flat file, and there would be questions like, in the Enron data set, which was available as a result of litigation, and we can also go back to Edgar filings. The question is, can you discover the shell game in the company based on like digging down in the disclosures?
Yeah.
And like, how can you do that? Who can do it fastest? Who can do it most completely? Can we get a dashboard on that so we can monitor things going forward? Another one is like we used to do all the time, like a few years ago, was a big data set from a government. On like we did a lot with cars and transportations, where people wanted to build really useful apps for traffic and for parking and other stuff. But the question is, have we adequately de-identified the data? Can you re-identify people? And some of those we did end up helped some of them to synthesize identity data and then de-identify it. So if they re-identified it, everyone wasn't sued. But maybe could those be examples of can we play these games with data?
I think so. It's in my mind more like what are those ways that, or like, is there a way to set up a pipeline for generating data like this almost?
And synthesizing it?
Yeah. So we can have like sort of a playground where we can work together to solve these issues.
This is a really, really hard problem, to be honest. It's harder than it sounds, what you're talking about, because it's so easy to do data inference. It's so easy. This is something, I mean, Sandy's lab and folks there have put a lot of effort into reversing, trying to understand, for a given set of data and a specific computation you might want to run on it, is it going to leak personal data or not? Right. And they've done a lot of work on de-anonymization and stuff like that. De-anonymization is surprisingly easy. It only takes a few data points to be able to work backwards and reconstruct or identify, probabilistically, who was this? I mean, there's only so many people that live at, one address and work at another one.
Yeah.
Right. And those are really interesting questions. But I think they're sort of, jumping farther out ahead of where we're all at as two separate communities right now, trying to put our thoughts together and find where the alignment is. That's one. I think that's probably a higher order set of problems.
Sure. Yeah. So let me ask another. So I've got a lot of questions myself. And do you mind reviewing some of the questions? See if there's any crisp points? Sure. But something that I've enjoyed talking about with you, and that might be interesting to others to think about, is this approach in cryptography to describing scenarios using a cast of characters that are where people kind of know what you mean when you say Alice, digitally signs a message to Bob, and Irving, and I can't remember them right now, but Grace, let's do Grace, would like to get, copies of all those messages as part of, maybe know your customer reporting or something like that. And then asking a question like, what are the opportunities for Grace to gain more knowledge or to perhaps introduce information security issues as a result of this? Could you talk a little bit about what are these cast of characters and how are they used in cryptography to describe basic patterns of situations? And then what I want to do from that is just crosswalk it back to what we do with legal fact patterns and how we do a legal analysis, and see if there's not something we can learn.
Yeah, so Alice and Bob stories are just kind of ubiquitous at this point in cryptographic circles talking about protocols. And they're deliberately really, really simple. Mm-hmm. They're simple because you want to be able to reason about them, mm-hmm. right? You don't want to see in the scenario. So like a secure messaging protocol, for example, would talk about Alice and Bob, and Alice wants to communicate with Bob. They want to communicate securely. They don't want Eve, the eavesdropper, mm-hmm. to hear or to be able to decipher what their message is. And so designing a protocol would be kind of looking at that scenario and looking at all the different ways that an attacker could possibly go about getting the information that's supposed to be hidden, and designing countermeasures for that. One of them, the obvious one in this case, would be encryption, to encrypt the message as it's being passed back and forth.
Okay, so and these characters in cryptography at least have kind of personas that are persistent, right?
Yeah, yeah. There's Eve, the eavesdropper, and there's Sybil, who will attack with multiple identities. There's Grace is a government agent that tries to subvert protocols. There's some for zero knowledge, like Peggy and Victor, I think, for zero knowledge proofs that show up. And there is just a whole collection of them. There are even judges and arbiters and different kinds of roles. And what you get from having this standard cast of characters is that it's really easy to understand a scenario very quickly. Like who's doing what here. You already know by their name kind of what their role is supposed to be, and it makes it easy to reason about them.
Here. So just to crosswalk that back a little bit, when I try to, first of all, understand cryptographic primitives and protocols, I've really come to appreciate and to get a lot of value from this constellation of characters as a quick way to express the relevant information about a scenario, so that I can kind of quickly get it and almost kind of express it like a syllogism or like a logic puzzle or something, and begin to kind of go through every permutation and go further faster. As I've looked in the law to see, is there something like, why can't we have nice stuff like that to quickly get to the bottom of what can sometimes be a murky? Lawyers are always saying it depends, and then you have to pay me to find out what that answer is and what it depends upon might be. Can we identify upon what factors does something depend in a repeatable way, and can we express this underlying scenario so that we can start to develop dependable and usable patterns. One thing I've found, I'll just throw out there for people to think about, and as a potential area for future work and student projects and research, startups, I don't know, is if you just say a legal scenario kind of out of the blue in a markdown document, you can get picked to death by, well, what about this and what about that? And it depends on all these other factors, and you start context shifting quickly in ways that you don't with the level of abstraction with Alice and Bob. There's one area where I found that where there is repeatable use of characters, and it's bar exams and certain law school like end of term exams, where we have a legal fact pattern, and they will say something like Jane purchased a used car from Alex, and Alex disclosed this amount of information, and this way Jane paid Alex on Thursday. On Friday, Alex discovered that that there was rust in the underbelly. It was going to cost $800 or something like that. And what are party A's rights against party B? What are party B's defenses? That kind of stuff. And what's interesting about them is that in the bar exam in particular, there's big committees of people that actually are the authoritative guardians of what the legal outcome would be, and so much so that they can tell you this with this amount of information, you should be able to give us this amount of certainty with results. And if you say these things, then you can be a lawyer. Like, they really are the keepers of our closest approximate to ground truth, without going and litigating a specific set of situations. And it's an abstract kind of fact pattern. We call it a legal fact pattern. I think it would be interesting some fine day to do something like the mock trial that we did together in this room, on getting digital signatures, cryptographic signatures into evidence in a case, to find maybe some well-worn bar exam questions and answers that have been published, and then crosswalk them with we have to do a little bit of creativity and stitching, but crosswalk them with a way to express them as Alice, Bob, Grace, Evelyn, kind of crypto scenario expression, and see if we can't truly align the business, legal, and technology dimensions of a situation and come up with better nomenclature so that we can know finally upon what things depend and how to structure things to start with. Could we do that, do you think? Is that, I know we had a devil of a time just kind of trying to lay a foundation to get a signature into evidence, but is that achievable?
I mean, I don't know about the getting it into evidence part, but the first place I would start to think to look would be something like band logic in formal analysis, like the logic of beliefs, where you're saying, Alice believes X and Charlie said Y, right? And you come up with this set of statements, and then there's a set of rules for reasoning about that, and it might not map exactly the same, but might be interesting to see. I mean, I think there's a sort of natural boundary. It's fuzzy to look at, but it exists in a real way, like laws of physics, principles kind of way of where technology leaves off and law kind of picks up.
Yeah, and there's some blur in there somewhere. I'd like to discover some.
There's some blur, but it's kind of a consistent blur.
Okay, I think it does. Yeah, it's not like Ben overlap.
Yeah.
If you zoom out far enough, you can clearly see that there is.
Yeah, I mean, you always know. I mean, if you understand law well enough, or you understand technology well enough, you probably have a pretty good intuition for where it's going to start to get fuzzy, right?
Yes. So before we go to another question, you said band logic. Well, what is band logic?
Band logic is a method of formal analysis for cryptographic protocols. BAN stands for Burroughs, Abadi, and Needham, and there were 3 cryptographers that came up with this. They're trying to answer the question of how can we know that a protocol is secure? I mean, and the answer is you can never really guarantee security, but you can try to systematically find flaws in a protocol design. And their approach is based on logic of belief, it's sometimes called, which kind of has some interesting legal things.
Very much so. I remember when you first mentioned this to me, and I did some exploration. There's many areas of law. Probably all areas of law include this somewhat, but some of them are almost mostly baked on it, such as agency law. When we really get down to what did a third party reasonably believe about the authorization of an agent with respect to doing business for a principal. And so, like the principal said, you can be my agent for purposes of selling my house. And then the agent to an agent, and the agent then went and
sold all the possessions
in the house. With a third party buyer, what would they have reasonably believed based on this statement and that relationship? And I think there's some areas where we could start to where we could apply band logic, and we could apply codes of law, such as the restatement of agency, which gives some pretty good rules about the roles of parties and the legal outcomes when certain situations happen among stated parties. In that case, it's almost always 3: a principal, an agent, and a third party, and something always goes terribly wrong. We have to figure out who's left holding the bag.
I don't know if these things map directly. I don't know if you could just start writing, band logic statements and kind of map that directly to law. But it is an interesting conceptual overlap in the idea. There's another one that's that I haven't really explored as much, called strand spaces. That kind of deals with a series of events for each actor, and then kind of trying to thread them together. It's really interesting. Really interesting.
So we can get into more sequences and flows, and maybe in a simple way. Sometimes we do swim lane diagrams, but strand logic takes it another level, right?
Yeah, it's a different approach.
Different approach. Okay, so some good things to be thinking about here. Band logic. Let's bone up on that. Strand spaces. Okay, so Brian, what do we have?
So there have been a couple of questions that are percolating kind of around ways that we protect information generally. So one of them, I'm going to kind of meld 2 into one, but one of them asked more about learning some about zero knowledge and other ways of protecting privacy, and then kind of the differences. The next one kind of wants to look at some of the differences between things that are hashed versus things that are encrypted. And just because something's hashed doesn't necessarily mean it's encrypted.
Sure. So both of those seem to kind of be looking for cryptographic answers to things that require starting from a couple of more basic steps, which is security goals and security principles. What is it that you're trying to achieve? You're trying to achieve confidentiality. Yeah, exactly. So there's a kind of mapping of the security goals to cryptographic primitives as countermeasures, but you're skipping a few steps if you just say, well, confidentiality, do encryption, and integrity, or authenticity, use a hash or something like that. You're missing a few steps. And I think people are misunderstanding the very, very basics of cryptographic primitives a lot of time in questions like this. And they're missing the idea that you have to have some goals, and then you have to have a threat model. You have to have some idea of what you're trying, how someone would try to break your security before you start choosing countermeasures. It could be completely worthless to encrypt something on disk if you're sending it in plain text and someone's packet sniffing and listening to the thing. Or I mean, there are any number of scenarios like that, and it's not necessarily good to just do everything, like go through a checklist of things that you're supposed to do and do everything, because then you're maybe increasing your attack surface. Maybe if you haven't thought about the interaction of protocols and things like that. People really need to be thinking first about what are their basic goals. And I could tell you an area where this is really, really murky and blurred and confused is when people are talking about blockchain and IPFS. Now you start comparing that to GDPR. Well, you have these things that have immutability as one of their stated principal characteristics, and then you have GDPR, which has this right to erasure, right? Well, but how do you reconcile those two things? You really can't. And there isn't any cryptography that's just a blanket answer to some problem like keep my data private. It doesn't work like that. We have to be a little more surgical and get a little more granular and solve very specific kinds of scenarios.
I'd like to get a little more surgical.
Sure.
Or actually, no, I'd like to introduce people to the idea of like a scalpel, suction, a gurney, oxygen, so that they can begin to think about performing surgery. And so
I really ask that you not encourage people to perform surgery.
I would like to provide more tools so people can begin thinking about building secure systems, and that also are enforceable and reliable with legal outcomes. Okay, yeah, no surgery. And so can you talk, going right from what you just said now about looking at security goals and goals generally, and mapping appropriately what your approach is going to be, so it's proportional and responsive to the goals. You mentioned basically the kind of like a threat model, but there's a particular thing I'd like to ask you to talk a little bit about for mapping threats, and it's the threat tree.
Attack tree.
Attack tree, excuse me, I meant to say attack tree. Yeah. Could you talk a little bit about attack trees in some kind of easy to understand context, so people can know what this process is, and we can start to think about in day 2 and 3 how we can apply it to some scenarios.
So let's say I have some bars of gold, right? And I'm not going to just leave them laying there when I go away, because somebody will probably come and pick them up and walk away. Yep. They're valuable. So I want to protect my bars of gold. Well, I go and I get a safe, right? And I put the bars of gold in the safe, and I close the door, and there's a one of those locks on it, a combination lock. And now it could be gold, maybe it's information. It doesn't matter what it is. But someone, let's say Sinjin, wants to get in the safe and walk away with the gold. He's from South Africa. Maybe they want to take it back.
Hard to extradite.
Yeah, and so there are a number of ways that that Sinjin could try to get in the safe. He could try to cut the safe open. Now we're starting to think about, we're starting to work backwards from the goal, right? And he could try to physically get access to the safe in a number of different ways. He could do a burglary. He could pretend to be the cable man and come in like they did in that movie with the with the little car, the minis.
Yeah.
What was that? The
Italian Job.
The Italian Job. Yeah,
good one.
Yeah. So there are a bunch of different ways that he could try to physically get access to the safe. Some of them could involve deception. It could involve violence. You could show up with a shotgun and blow the doors off and walk in and start shooting people or something. Or he could he could be deceptive about it. He could sneak in when nobody's home, and then he gets to the safe and he has to figure out how to open it. Well, in order to open it, he's got to either know the combination or he has to have a way to cut open the safe. Then there's this notion of security life cycle that comes into it. If Sinjin was really, really sophisticated, maybe he knows the safe manufacturer and maybe he is able to subvert the manufacturing process or insert a back door so that he knows the manufacturer and he could find the back door.
So we're into master keys, that kind of stuff.
Exactly, all these different things. And so attack trees are this process of starting from the goal and working backwards in all the ways that someone could attack it. And you think about a lot of different aspects in this, like what's the life cycle of the thing that you're trying to protect, right? Like we talked about, he could just show up and break the thing. That's like right now it's deployed as a countermeasure, but he could try to break it before it's ever in use. There was a case recently that I think it was disproved, but there was an accusation of chips, coming from China with some
The ballpoint
vulnerabilities to eavesdrop.
Yeah. For the trade secrets.
Yeah.
IP issues.
Yeah. So you kind of have to be a combination of naughty and methodical to think about all the ways that you could potentially break something like this. And an attack tree is this big tree that you build up by working backwards to solve all the sub problems until you get down to the basic leaves. Well, he could or something like that.
So the branch would be all the ways he could wrongfully discover the combination.
Exactly.
All the ways he could forcibly enter. He could use some C4 and blow it. He could use a blowtorch. He could use it. All the ways in which he could take the safe and get and abscond with it and then deal with it later. And so these are like branches to twigs to leaves.
That's right. And when you get down to the leaves of the tree, that's where you can start analyzing the tree, and you can start to prune out which of these things aren't really feasible.
Yes.
You can weight them, and you can say which ones are very, very costly, or that make them infeasible because of the cost, or because it's physically impossible to do certain things to molybdenum or something. I don't know. You could basically find ways to narrow down to what are the feasible attacks, and then from there, now you're really starting to think about what's important to address here. Not everything that you could address, not hypothetical things, but things that actually, this is a sort of a risk process, risk management. You could put weights on these things to figure out which are the most important ones, what's the most likely, and then once you have them, you start thinking about what are all, for each leaf, what are all the possible countermeasures? What are all the ways that you could go, or what are all the ways you could go about preventing an attack on that, right? Or preventing that attack. There might be many of them. Some of them might be very inexpensive, but completely ineffective, or they might be very expensive and completely ineffective, right? So you have to you have to kind of evaluate all of that, and then make some choices that are optimized around your goals, your means, your, you know, do you have maybe a certain countermeasure requires that you have is an armed guard,
right?
Okay, but you can't afford to pay the armed guard, but you could afford to pay your German Shepherd, you know, dog food, and that's one kind of countermeasure, right?
Here. I remember in the I'll just put out there, so in case, so don't. What Christian's saying is an informal response to a question, giving examples of things, but just to put a little more meat on permutations of some of the questions you'd ask. It's not, of course, always about preventing the attack on a leaf, but sometimes it's about mitigating or allowing some attacks are too expensive or don't make sense to prevent, but you can detect them before they're completed.
The life cycle.
And that gets into the life cycle.
Detection and response.
And then sometimes you could do something where you basically render the goods unusable. So it's like, well, we can do some deterrence here and some other things like that. So so thank you for explaining that. And I like encourage people to be thinking about this kind of structured thinking when looking at threats and potential attacks. When modeling the legal aspects of systems, or as well, because a lot of what we think about in the law is when something goes wrong. It's sources of liability, sources of damages, and ideally preventing that, but also mitigating it and absorbing somehow the risks of harm. And so I think we have a lot to learn, especially as the legal dimension, the business dimension, the technology dimension of online systems very much collapse into one thing.
Yeah.
We'll need to learn how to be conversant with this. Speaking of being conversant, I see it's about 4 o'clock now, and people have stuck with us. But I'd like to ask if you could you stick with us while we close out the session? Sure. Quick. Hey, welcome back. So quick question from the core team is, before I do a synthesis and wrap up, is there anything come up or anything to address?
I guess the only announcement is that after this evening we'll send out a resource list, all the resources that students ask for throughout the day.
Do you guys want, can you join us? Sure. If you're willing? Okay, and just pull a couple chairs up. Oh, and so actually I want to thank you, Christian. Awesome tour de force. Christian Smith, Stranger Labs, you're always welcome here. Thank you. Okay, so now we come to the wrap up. So actually, can you relinquish the chair? Sorry, I said stay and I said go. It's always whatever the most recent thing I said was, I suppose. Okay, great. Welcome, core team. Can you just actually say what?
Yeah.
What those?
So this evening we're going to assemble all the resources you guys asked for throughout the day, and then we'll send it out all aggregated in an email. So look out for that before class tomorrow.
You're here. Another thing that I think does not go without saying is tomorrow we, by popular demand, are going to do a couple of online sessions. We've got some things happening in person at the Media Lab. I know virtually nobody watching this is here in the area, so but if you are here and you're interested in the in-person events, check out the page and for more information about that. We have some folks from the Red Bull team, I think, with us now. IBM Hyperledger is going to join us, and George Howard will be primarily leading that session as we try to solve for some open music initiative use cases. For all of you, tomorrow we're going to be doing three two sessions of online sessions. The first one is at 1 p.m. to 1:45 p.m.
Yep.
And the second one is at
2
something to something.
Oh, 2:30 to 3:50.
2:30 to
3:15. Oh,
15. So a couple of 45-minute sessions, and so a key thing we're going to do when we come together tonight and look through all of the feedback that you've given and synthesize responses to the requests you have for more resources is we'll come up with a specific, simple as possible way that you can opt into the different concurrent sessions. So we'll start doing breakout sessions. What you can expect tomorrow for the breakouts are what?
So tomorrow we're going to have Juan's breakout session one of Juan's breakout sessions with Inserio, and they will be going through some of the different ways that you can build interoperable apps and legal services. And they're specifically looking at apps that they've done in the Relativity platform and how, those can be useful, and kind of synthesizing a general sort of approach over the course of his lecture on Wednesday and his lecture on Thursday.
Yep. And so and then Sarah will be doing that walkthrough, and they've got 4 apps that they've actually kind of built to provide as toy kind of prototype examples to walk you through how to develop and integrate something for a REST interface and get your OAuth tokens and what the data looks like in JSON, and be very informative. So we'll do one in the first session and a second one in the second session.
Yep.
And then we have more breakouts.
Yep.
What else?
And so in the afternoon, we'll be doing the computational jurisdiction breakout session.
Right.
That's the
I'm looking at Brian. And so
the Brian and Brian show.
That the defendant raised his eyebrows.
Right. Can you point out the person that was going to help us do that session? That is basically a session that was posed by this very creative counsel and General Electric, Christoph Pereira. And when General Electric moved to Boston for their headquarters, they became, among other things, a sponsor and member of the Media Lab. We've had great relations on the research side between law.MIT.edu research and their legal research, their legal team, which is like thousands of lawyers, well engineered at GE. It's not an endorsement. And there's and so he posed at the MIT Legal Forum like a year and a half ago this idea that's still very forward-looking. How can we have a computational jurisdiction? How could that work? So check out the video in the breakout page for that. And Brian, you listening, will kindly join Brian Wilson to help facilitate a discussion on what areas of law could be ready to be completely modeled computationally. What sort of data would drive application of those rules, and what sort of algorithms would be used? How could we design and test something like that? And so Christoph kind of puts the gauntlet down with a challenge, and we're going to try to brainstorm a little bit and talk about that challenge tomorrow.
Any word from Christoph himself?
That email was writing this morning, so Christoph doesn't know that we're talking about his session yet, and I'm going to email him as soon as we're off air to let him know. And hope that what we need to do is ask him, do you have any ideas of things that we should talk about, or do you have any further thinking on that? And obviously he's also invited. If he comes in, he should lead the session. Do we have any other breakout sessions tomorrow?
Jameson, right?
Yeah.
Oh yeah, and Jameson Dempsey, who is the acting chair of Legal Hackers International, is going to give us a little overview of this organization. He's got some great slides and a great talk there, and he'll talk a little bit about ways people can get involved all around the world and the type of activities that we do. And this workshop course in our open format is very much one facet of the sorts of things that you can learn more about and participate in globally through Legal Hackers.
Yep.
We are all legal hackers.
We're all legal hackers.
And so that will be a very good one. And then that'll be what happens online Thursday. Wednesday tomorrow. And then we're going to try to get even better at this and do 6 concurrent breakouts on Thursday, where you can in a more fine-tuned way, you can choose your breakout. We've got some basic preferences from you from the Google form. And I think what we're going to do then, just so you're not surprised by this, is, and you can see this on the agenda, but we'll start the day with the breakout leaders, about exactly half of which are in person, about half of which are online. We'll just reintroduce themselves, say like a minute about like a fire starter, minute or two about what their breakout session is about. And then after about 10 or 12 minutes of that, we'll have an opportunity where people can select what breakout they're in. And if some breakouts don't have enough interest, then we won't do those breakouts. Then if breakouts have too much, we may see like what's your first choice, second choice, third choice, and do some load balancing. Based on the form, it looks like there's pretty well balanced interest in all the breakouts. So, and in my book, it's probably like 2 or 3 or more people makes a great breakout session. What matters most is what you're interested in, and that's what will make a rich dialogue. And we've got some really great ways where we, the 4 of us as the core team, and then some and help kind of orchestrate that. And we'll more about exactly how we'll do that. Will be announced after we figure out how we're going to do tomorrow and see exactly what's working well for those breakouts. So we may iterate and adjust as we go. Probably.
I think that covers it.
So I just want to say thank you all for joining us and hacking the law with us over this first auspicious start day of a computational law course of 2019. You've been great. I've been reading as best I can. It's like sipping from a fire hose on our television channel, and it's been really interesting.
Yeah.
And thank you also very much for playing along with us and trying out this pigeonhole tool. And let's see if we can't refine that a little bit too, so that we can get more engagement on upvoting. I think would be the thing that most helps us key in on the things that you want us to address. So that's a work in progress. So thank you all for very much co-creating this course with us this year. And so we shall watch for those emails and tell at 1 p.m. Eastern when we go live again. So now, in honor of our legal hacker friend Poppers, we'll carry it out.
Happy birthday to. It's his birthday.
Happy birthday